A resolution passed by the Mvskoke Creek National Council and signed by Principal Chief James Floyd on August 31st has authorized the Executive Office to formally request a tribal court assessment from the U.S. Bureau of Indian Affairs Office of Justice Services. The resolution indicates that the assessment targets technical and training needs and to provide funding to areas of tribal court that need assistance.
The program is intended to be a very collaborative review. It looks at what we see at the present time, strategic planning in terms of what we want to do for the longer term, and then the identifiable support that we need. And so it does come with the access to funding that we sorely need.
According to the OJS website section on tribal court assessments, there are 5 steps involved in the process: document gathering, initial on-site meeting, multi-day on-site assessment, present findings and recommendations, and follow-up and next steps. The tribe is then eligible for possible one-time funding for qualifying needs that are identified by the assessment. For Floyd, his area of focus was on being able to attain available funds to equip the court with everything they need.
I know the court has identified to me minor needs they have, equipment needs, security needs, and things like that. And so they could use one-time funding to purchase these things and to assist the court, help ensure their safety for the staff and for the people who are in the courtroom. And so I think in that regard, it's very much in our interest to make sure that we have the review and we get the resources so that we can just assure everybody that our court system is safe and we have the latest equipment that we can to operate.
When asked if this assessment request was an indicator of any concerns his office has with the way that the tribal court is performing its duties, Floyd indicated that it was not his motive.
The Tribal Justice Program review is not related to any cases that have been in the court system recently or may be in the court system in the future. It's totally independent. The reason I wanted the authorization at this point is that it allows me the authority to schedule with them at some point in the future. The program will not be extended over another year, and so if we hesitated too much longer, then we wouldn't have the ability to have them come out and do the review or have the access to the resources. So, that's the kind of the lane that I'm looking at in terms of this issue, and not seeing it as linked to anything that the court may be doing independent of this.